All right, here's what happened. Clean, clear, and documented. On Thursday, Judge Alvin Hellerstein looked at Donald Trump's legal team, looked at their motion, and said, in effect, no, denied. What's at stake? 83.3 million. Trump's lawyers tried to reopen an issue the court had already decided. Same arguments, new packaging. Judge Hellerstein wasn't buying it. According to court filings in the Southern District of New York, the judge called it exactly what it was: a second bite at the apple. And federal courts don't work that way. I read the full 47-page decision. The language is surgical and brutal. First, some context. Judge Alvin Hellerstein is a senior U.S. district judge. He's been on the bench since 1998, appointed by President Clinton. He handled 9/11 litigation. He handled Guantanamo cases. This is not a judge who gets confused or rattled by aggressive lawyering. The issue here is simple. Trump's legal team tried to relitigate damages in the E. Jean Carroll defamation case after the jury decided, after the appeals court affirmed, and after multiple post-trial motions failed. Timeline, fast version. Months ago, a jury awards Carroll $83.3 million. Weeks ago, the Second Circuit affirms key portions of that verdict. Last Monday, Trump's attorneys file a new motion claiming newly discovered procedural grounds. Thursday, Judge Hellerstein shuts it down. That's the setup. What makes this ruling different isn't just the denial, it's the explanation. Hellerstein didn't just say no, he laid out, page by page, why what they tried cannot work under federal law. On page 23, the judge writes, quoting here, "The doctrine of issue preclusion bars relitigation of matters already determined by a court of competent jurisdiction. This motion seeks precisely what the law forbids." Translation: once something is decided, you don't get to come back with the same argument wearing a different hat. Then it gets sharper. On page 31, Hellerstein addresses Trump's claim that a procedural issue involving jury instructions created new grounds for relief. The judge responds, "This argument was available at trial. It was available on appeal. Counsel chose not to raise it. The failure to previously assert an argument does not transform it into a newly discovered basis for relief." That's devastating. He's saying, you had this argument the whole time. You didn't use it. You don't get credit now for discovering something that was already in your pocket. The pattern becomes obvious. The motion was filed February 3rd. It claimed a new legal basis. Hellerstein traces that basis directly back to the trial record. Trump's own attorneys referenced similar arguments in earlier filings. The court concludes, not new, just repackaged. And here's something most coverage missed. On page 38, footnote 14, Hellerstein cites 11 prior cases in this circuit where courts rejected similar second bite attempts. In 3 of those cases, sanctions were considered. He doesn't impose sanctions here, but citing them is a warning shot. Then there's page 41. Trump's team didn't just challenge the verdict. They suggested judicial bias, implying Judge Hellerstein should have recused himself. The response? The suggestion that this court's adherence to established precedent constitutes bias mistakes disagreement for discrimination. The law does not bend to preferred outcomes. That's a full dismantling in 17 words. The result? The $83.3 million judgment stands. Another procedural option is gone, and the language in this ruling makes future attempts harder. Now, fairness matters. Trump's legal team does have an argument, at least structurally. They say this motion wasn't about relitigating. It was about correcting a fundamental procedural error affecting due process. They point to a footnote in the Second Circuit's opinion discussing damages standards and argue that it changed the legal landscape. Alina Habba put it this way: "We're not asking for a do-over. We're asking the court to address an error it created." That's not nothing. The footnote exists. Courts sometimes reconsider issues when circumstances genuinely change. Even critics of Trump's litigation strategy admit this motion wasn't frivolous in the technical sense, but here's the reality. Judge Hellerstein didn't buy it. He saw the arguments, traced them back to earlier proceedings, and called it what it was: procedural recycling. And then he did something unusual. On page 46, Near the end of the ruling, he wrote that any future motions raising substantially similar arguments, even under different procedural labels, would be subject to summary denial without briefing. Then he added, the court will not serve as a venue for indefinite procedural cycling. That's not standard language. That's a judge saying, I'm done. Carroll's attorney, Roberta Kaplan, responded with one word that matters: collection. Because while motions fly, that judgment is enforceable. Trump's team filed a notice of appeal the next day. Expected, routine. But here's the tell. They're reframing this as a constitutional due process issue. That's escalation. It's also a long shot. Legal experts across the spectrum agree. The motion was technically proper, strategically weak, and the standard of review on appeal, abuse of discretion, is brutal. With 47 pages of reasoning, Supreme Court doctrine, and multiple circuit citations, that bar is very high. Where does that leave us? The denial stands. The appeal clock is running. Carroll's team is focused on enforcement. This ruling isn't just about Trump. It reinforces a basic rule of federal court. You get a trial, you get an appeal, but you don't get infinite retries. Finality has to mean something. Judge Hellerstein put that in writing. The story isn't over, but the path forward just got a lot narrower. I'll be watching the Second Circuit docket. When the briefs drop, when enforcement moves start, when anything changes, I'll break it down. Documents matter, details matter. And in cases like this, delay versus defeat lives in the procedural weeds. I read the filing so you don't have to. Talk soon.